Hello, my name is Natalie Keller, and I'm presenting the portion of this Minors Council training that has to deal with the Family Code sections and the California Rules of Court. We first start with Family Code Section 3150, Section A, that states, if the court determines that it would be in the best interest of the minor child, the court may appoint private counsel to represent the interests of the child in a custody or visitation proceeding, provided that the court and counsel comply with the requirements set forth in Rules 5.240, 5.241, and 5.242 of the California Rules of Court. Section B states, upon entering an appearance on behalf of a child pursuant to this chapter, counsel shall continue to represent that child unless relieved by the court upon the substitution of other counsel by the court or for cause. Family Code Section 3151 states, the child's counsel appointed under this chapter is charged with the representation of the child's best interest. The role of child's counsel is to gather evidence that bears on the best interest of the child and present that admissible evidence to the court in any manner appropriate for the counsel of a party. If the child so desires, the child's counsel shall present the child's wishes to the court. The counsel's duties, unless under the circumstances is inappropriate to exercise the duty, include interviewing the child, reviewing the court files, and all accessible relevant records available to both parties, and making any further investigation as the counsel considers necessary to ascertain evidence relevant to the custody or visitation hearings. Section B states, counsel shall serve notices and pleadings on all parties, consistent with requirement for parties. Counsel shall not be called as a witness in the proceeding. Counsel may introduce and examine counsel's own witnesses, present arguments to the court concerning the child's welfare, and participate further in the proceeding to the degree necessary to represent the child adequately. The child's counsel shall have the following rights: reasonable access to the child, standing to seek affirmative relief on behalf of the child, notice of any proceeding in all phases of that proceeding, including a request for examination affecting the child, the right to take any action that is available to a party to the proceeding, including but not limited to the following: filing pleadings, making evidentiary objections, and presenting evidence and being heard in the proceeding, which may include but shall not be limited to presenting motions and orders to show cause, and participating in settlement conferences, trials, seeking writs, appeals, and arbitration. Access to the child's medical, dental, mental health, and other health care records, school and educational records, and the right to interview school personnel, caretakers, health care providers, mental health professionals, and others who have assessed the child or provided care to the child. The release of this information to counsel shall not constitute a waiver of the confidentiality of the reports, files, and any disclosed communication. Counsel may interview mediators. However, the provisions of Section 3177 and 3182 shall apply. The right to reasonable advance notice of and the right to refuse any physical or psychological examination or evaluation for purposes of the proceeding which have not been ordered by the court. The right to assert or waive any privilege on behalf of the child. The right to seek independent psychological or physical examination or evaluation of the child for purposes of the pending proceeding upon approval by the court. Family Code Section 3152 states in Section A, the child's counsel may, upon notice motion to all parties and the local child protective service agency, request the court to authorize release of relevant reports or files concerning the child represented by the counsel of the relevant local child protective services agency. The court shall review the reports or files in camera in order to determine whether they are relevant to the pending action and whether and to what extent they should be released to the child's counsel. Section C states, neither the review by the court nor the release to counsel shall constitute a waiver of the confidentiality of the reports and files. Counsel shall not disclose the contents or existence of the reports or files to anyone unless otherwise permitted by law. Family Code Section 3153 states in Section A, If the court appoints counsel under this chapter to represent the child, counsel shall receive a reasonable sum for compensation and expenses, the amount of which shall be determined by the court. Except as provided in subdivision B, this amount shall be paid by the parties in the proportion the court deems just. Section B states, upon its own motion or that of a party, the court shall determine whether both parties together are financially unable to pay all or a portion of the costs of counsel appointed pursuant to this chapter, and the portion of the cost of that counsel which the court finds the parties are unable to pay shall be paid by the county. The judicial council shall adopt guidelines to assist in determining financial eligibility for county payment of counsel appointed by the court pursuant to this chapter. The 2024 California Rules of Court Rule number 5.240 addresses appointment of counsel to represent a child in family law proceedings. In Section A, appointment considerations. In considering appointment counsel under Family Code Section 3150, the court should take into account the following factors, including whether the issues of child custody and visitation are highly contested or protracted, the child is subject to stress as a result of the dispute that might be alleviated by the intervention of counsel representing the child, counsel representing the child who would likely be there to provide the court with relevant information not otherwise readily available or likely to be presented. The dispute involves allegations of physical, emotional, or sexual abuse or neglect of the child. It appears that one or both parents are incapable of providing a stable, safe, and secure environment. Counsel is available for appointment who is knowledgeable about the issues being raised regarding the child in the proceeding. The best interest of the child appears to require independent representation, and if there are two or more children, any child would require separate counsel to avoid a conflict of interest. B, request for appointment of counsel. The court may appoint counsel to represent the best interest of the child in a family law proceeding on the court's own motion, or if requested to do so by either a party, the attorney for a party, the child or any relative of the child, a mediator under Family Code Section 3184, a professional person making a custody recommendation under Family Code Sections 3111 and 3118, Evidence Code Section 730, or Code of Civil Procedure Section 2032.010 et sec, a county counsel, district attorney, or city prosecutor authorized to prosecute child abuse and neglect or child abduction cases under state law, or a court-appointed guardian ad litem or special advocate, or any other person who the court deems appropriate. Section C addresses orders appointing counsel for a child. The court must issue written orders when appointing and terminating counsel for a child. The appointment orders must specify the following: appointed counsel's name, address, and telephone number, name of the child for whom counsel is appointed, and child's date of birth. The appointment orders may include the child's address if appropriate, issues to be addressed in the case, tasks related to the case that would benefit from the services of counsel for the child, responsibility and rights of the child's counsel, counsel's rate or amount of compensation, allocation of fees payable by each party or the court, source of funds and manner of reimbursement for counsel's fees and costs, allocation of payment of counsel's fees to one party subject to reimbursement by the other party, terms and amount of any progress or installment payments, and the ability of the court to reserve jurisdiction to retroactivity and to retroactively modify the order on fees and payment. Courts may use order appointing counsel for a child, that's Form FL 323, or may supplement Form FL 323 with local forms developed under Rule 10.613. D, panel of counsel eligible for appointment. Each court may create and maintain a list or panel of counsel meeting the minimum qualifications of this rule for appointment. Section 2 states if a list or panel of counsel is maintained, A court may appoint counsel not on the list or panel in special circumstances, taking into consideration factors including language, culture, and the special needs of a child in the following areas: child abuse, domestic violence, drug abuse of a parent or the child, mental health issues of a parent or the child, particular medical issues of the child, and educational issues. If the court maintains a panel of counsel eligible for appointment and the court appoints counsel who is not on the panel, the court must state the reason for not appointing a panel counsel in writing or on the record. Any lists maintained from which the court might appoint counsel should be reviewed at least annually to ensure that those on the list meet the education and training requirements. Court should ask counsel annually to update their information and to notify the court if any changes would make them unable to be appointed. Letter E, complaint procedures. By January 1st, 2010, each court must develop local court rules in accordance with Rule 10.613 that provide for acceptance and response to complaints about the performance of the court-appointed counsel for a child. And Section F, termination of appointment. On entering an appearance on behalf of a child, counsel must continue to represent that child until the conclusion of the proceeding for which counsel was appointed, relieved by the court, substituted by the court with other counsel, removed on the court's own motion or request of counsel or parties for good cause shown, or the child reaches the age of majority or is emancipated. California Rules of Court Rule 5.241 discusses compensation of counsel appointed to represent a child in a family law proceeding. Section A discusses determination of counsel's compensation. The court must determine the reasonable sum for compensation and expenses for counsel appointed to represent the child in a family law proceeding, and the ability of the parties to pay all or a portion of counsel's compensation and expenses. The court must set compensation for the child's counsel at the time of appointment, at the time the court determines the party's ability to pay, or within a reasonable time after appointment. No later than 30 days after counsel is relieved as counsel of record, the court may make a redetermination of counsel's compensation. They can do that on the court's own motion, at the request of a party or party's counsel, or at the request of counsel for the child. Determination of ability to pay. The court must determine the respective financial ability of the parties to pay all or a portion of counsel's compensation. 1, before determining the party's ability to pay, the court should consider factors such as the party's income and assets reasonably available at the time of the determination, and eligibility for or existence of a fee waiver under the Government Code Section 68511.3, and the parties must have on file a current income and expense declaration, the FL-150, or a financial statement simplified, the FL-155. The court should determine the party's ability to pay at the time counsel is appointed, within 30 days after appointment, or at the next subsequent hearing. No later than 30 days after counsel is relieved as attorney of record, the court may redetermine the party's ability to pay on the court's own motion or at the request of counsel or the parties. Payment to counsel. If the court determines that the parties have the ability to pay all or a portion of the fees, the court must order that the parties pay in any manner the court determines to be reasonable and compatible with the party's financial ability, including progress or installment payments. The court may use its own funds to pay counsel for a child and seek reimbursement from the parties. The court must inform the parties that the failure to pay to the appointed counsel or to the court may result in the attorney or the court initiating legal action against them to collect the money. Parties' inability to pay. If the court finds that the parties are unable to pay all or a portion of the costs of the child's counsel, the court must pay the portion of the parties that they are unable to pay. California Rule of Court 5.242 discusses qualifications, rights, and responsibilities of counsel appointed to represent a child in a family law proceeding. Section A discusses the purpose. This rule governs counsel appointed to represent the best interest of the child in a custody or visitation proceeding under Family Code Section 3150. Section B discusses the general appointment requirements. To be eligible for appointment as counsel for a child, counsel must, 1, be an active member in good standing of the State Bar of California. 2, have professional liability insurance or demonstrate to the court that he or she is adequately self-insured. And 3, meet the education, training, and experience requirements of this rule. Section C, education and training requirements. Effective January 1st, 2009, before being appointed as counsel for a child in a family law proceeding, counsel must have completed at least 12 hours of applicable education and training, which must include all of the following subjects: statutes, rule of court, and case law relating to a child custody and visitation litigation, representing and representation of a child in custody and visitation proceedings, special issues in representing a child, including the following: various stages of child development, communicating with the child at various developmental stages and presenting the child's view, recognizing, evaluating, and understanding evidence of child abuse and neglect, family violence and substance abuse, cultural and ethnic diversity, and gender-specific issues, the effects of domestic violence and child abuse and neglect on children, and how to work effectively with multidisciplinary experts. Annual education and training requirements. Effective January 1st, 2010, to remain eligible for appointment as counsel for a child, counsel must complete during each calendar year a minimum of 8 hours of applicable education and training in the subjects listed in Section C above. Section E discusses applicable education and training. Education and training that addresses the subjects listed in Section C above may be applied toward the requirements of this rule if completed through a professional continuing education group, an educational institution, a professional association, a court-connected group, or a public or private for-profit or not-for-profit group. A maximum of 2 of the hours may be self-study under the supervision of an education provider that provides evidence of completion. Counsel may complete education and training courses that satisfy the requirement of this rule offered by the education providers in Section 1 by means of video presentations or other delivery means at remote locations. Such courses are not self-study within the meaning of this rule. Counsel who serve as an instructor in an education and training course that satisfy the requirements of this rule may receive 1.5 hours of course participation credit for each hour of course instruction. All other counsel may claim credit for actual time he or she attended the education and training course. Experience requirements. Persons appointed as counsel for a child in a family law proceeding must have represented a party or a child in at least 6 proceedings involving child custody within the preceding 5 years as follows. A, at least 2 of the 6 proceedings must have involved contested child custody and visitation issues in family law. And B, child custody proceedings and dependency or guardianship cases can count for no more than 3 of the 6 required for appointment. Section 2, courts may develop local rules that impose additional experience requirements for persons appointed as counsel for a child in a family law proceeding. G, alternative experience requirements. Counsel who does not meet the initial requirements in letter F may be appointed to represent a child in a family law proceeding if he or she meets one of the following alternative experience requirements. Counsel must, 1, be employed by a legal services organization, a governmental agency, or a private law firm that has been approved by the presiding or supervising judge of the local family court as qualified to represent a child in family law proceedings and be directly supervised by an attorney in an organization, an agency, or private law firm who meets the initial experience requirements in letter F above. 2, be an attorney working in consultation with an attorney approved by the presiding or supervising judge of the local family court as qualified to represent a child in family law proceedings. Or 3, demonstrate substantial equivalent experiences determined by local court rule or procedure. H, compliance with appointment requirements. A person appointed as counsel for a child must 1, file a declaration with the court indicating compliance with the requirements of this rule no later than 10 days after being appointed and before beginning work on the case. Counsel may complete the declaration of counsel for a child regarding qualifications, Form FL322, or other local forms for this purpose. And 2, notify the court within 5 days of any disciplinary action taken by the State Bar of California, stating the basis of the complaint, result, and notice of any reproval, probation, or suspension. Letter I, rights of counsel for a child. Counsel has rights relating to the representation of a child's best interest under Family Code Sections 3111, 3151, 3151.5, and 3153, and Welfare and Institutions Code Section 827, which include the right to reasonable access to the child, to seek affirmative relief on behalf of the child, notice to any proceeding in all phases of that proceeding, including a request for examination affecting the child, take any action that is available to a party to the proceeding, including filing pleadings, making evidentiary objections, and presenting evidence, being heard in the proceeding, which may include presenting motions in order to show cause, and participating in settlement conferences and trials, seeking writs, appeals, and arbitrations. Access to the child's medical, dental, mental health, and other health care records, and school and educational records, inspecting juvenile case files subject to the provisions of Welfare and Institution Code Section 827, interview school personnel, caretakers, healthcare providers, mental health professionals, and others who have assessed the child or provided care to the child. However, the release of this information to counsel does not constitute a waiver of the confidentiality of the reports, files, and any disclosed communications. They may interview mediators subject to the provisions of Family Code Section 3177 and 3182. They're to receive reasonable advance notice of and the right to refuse any physical or psychological examination or evaluation for purpose of the proceeding that has not been ordered by the court. Assert or waive any privilege on behalf of the child, seek independent psychological or physical examination or evaluation of the child for the purpose of the proceeding on approval by the court, receive child custody evaluation reports, not be called as a witness in the proceedings, request the court to authorize release of relevant reports or files concerning the child represented by the counsel of the relevant local Child Protective Services agency, and receive reasonable compensation and expenses for representing the child, the amount of which would be determined by the court. Responsibilities of counsel for a child. Counsel is charged with the representation of the child's best interest. The role of the child's counsel is to gather evidence that bears on the best interest of the child and present that admissible evidence to the court in any manner appropriate for the counsel of a party. If the child so desires, the child's counsel must present the child's wishes to the court. Counsel's duties, unless under the circumstances is inappropriate to exercise the duty, includes under the Family Code Section 3151, interview the child, review the court files and all accessible relevant records available to both parties, and making any further investigations that counsel considers necessary to ascertain the facts relevant to the custody or visitation hearings. Counsel must serve notices and pleadings on all parties consistent with the requirements for parties. Counsel may introduce and examine witnesses, present arguments to the court concerning the child's welfare, and participate further in the proceeding to the degree necessary to represent the child adequately. In any case in which counsel is representing a child who is called to testify in the proceeding, counsel must provide information to the child in an age-appropriate manner about the limitations on confidentiality and the possibility that information provided to the court may be on record and provided to the parties in the case. Allow but not require the child to state a preference regarding custody or visitation, and in an age-appropriate manner, provide information about the process by which the court will make a decision. Provide procedures relevant to the child's participation, and if appropriate, provide an orientation to the courtroom where the child will be testifying. Inform the parties, other professionals serving on the case, and then the judicial officer about the client's desire to provide input and address the court. And if so informed by the child at any point, provide notice that the child has changed their choice about addressing the court. Notice must be provided as soon as feasible to the parties or their attorneys, other professionals serving on the case, and then to the judicial officer. Other considerations. Counsel is not required to assume the responsibilities of a social worker, probation officer, child custody evaluator, or mediator, and is not expected to provide non-legal services to the child. Subject to the terms of the court order of appointment, counsel for a child may take the following actions to implement his or her statutory duties in representing a child in a family law proceeding. Interview or observe the child as appropriate to the age and circumstances of the child. In doing so, counsel should consider all possible interview or observation environments and select a location most conducive to both conducting a meaningful interview of the child and investigating the issues relevant to the case of the time, in a manner and to the extent consistent with the child's age, level, maturity, and ability to understand, and consistent with the order of appointment for the case. Explain to the child at their first meeting counsel's role and the nature of the attorney-client relationship, including confidentiality issues, and advise the child on a continuing basis of possible courses of action and the risks and benefit of each course of action. Actively participate in the representation of the child at any hearings that affect custody and visitation of the child, and attend and participate in any other hearings relevant to the child. In doing so, counsel may, as appropriate, take positions relevant to the child on legal issues before the court, seek and advocate for services of the child, prepare for any hearings or trials, work to settle contested issues and to define trial issues, prepare witnesses, including the child if the child is to testify, introduce and examine witnesses on behalf of the child, cross-examine other witnesses, make appropriate evidentiary objections, review court files and other pertinent records, prepare motions to advance the child's interest, including motions to quash, subpoenas for the child and other protective orders, present arguments to advance the child's interest, prepare trial briefs and other documents if appropriate, and request appointment of separate appellate counsel. Conduct thorough, continuing, and independent investigations and discovery to protect the child's interests, which may include obtaining necessary authorizations for the release of information, reviewing the child's social services, mental health, drug and alcohol, medical, law enforcement, education, and other records relevant to the case, reviewing the court files of the child and his or her siblings, case-related records of the social service agency, and case-related records of other service providers, contacting attorneys for the parties and non-lawyer guardian ad litem, court-appointed special advocates, also known as CASAs, and other service professionals to the extent permitted by local rule for background information, contacting and meeting with the child's parents, legal guardians, or caretakers with permission of the attorneys, interviewing witnesses and individuals involved with the child, including school personnel, child welfare caseworkers, foster parents, and other caretakers, neighbors, relatives, coaches, clergy, mental health professionals, physicians, law enforcement officers, and other potential witnesses, reviewing relevant photographs, video or audio recordings, and other evidence, documenting the results of these investigations, monitoring compliance with court orders as appropriate, including the provisions for and effectiveness of any court-ordered services, promoting the timely progression of the case through the judicial system, investigating the interests of the child beyond the scope of the proceeding, and reporting to the court other interests of the child that may need to be protected by the institution of other administrative or judicial proceedings. However, counsel is not responsible for instituting those proceedings or representing the child in them unless expressly appointed by the court for that purpose. And after learning of other existing administrative or judicial proceedings involving the child, communicating and cooperating with others to the extent necessary and appropriate to protect the child's interests, taking all other steps to represent the child adequately as appropriate to the case, including becoming knowledgeable in other areas affecting minors, specifically the Indian Child Welfare Act, information about local experts who can provide evaluation, consultation, and testimony, and delinquency, dependency, probate, family law, and other proceedings.